process, as well as the review and appeal process after a CPS finding of child abuse or neglect is made. As Krista mentioned, this kind of sprung out of some public comments that were made at the last DCYF Oversight Board by individuals that raised some concerns about the way CPS findings are made and the opportunity that individuals have or don't have to contest those findings. So I commented to Krista Johnson, I thought it might be a good opportunity to share background information on that process with the Oversight Board. I know that some of you professionally are very familiar with this process. Others, this may be relatively new information. But again, I thank you for the opportunity to present this information. Go ahead and share my screen and we'll get started. All right, can everyone see the PowerPoint set up? All right. So what we'll discuss is the CPS finding of child abuse and neglect and the opportunities that the subject of a finding has to challenge those findings. It will include a review of the administrative review process, and Dr. Joel Adimba will discuss that. And that's the kind of first stage of review after the CPS finding of child maltreatment is made. Judge Sheila Huber will discuss in detail the Office of Administrative Hearings role in the appeal process. The PowerPoint will also address kind of the stage after the administrative hearing, which is the DCYF Board of Appeals. And I also want to describe a little bit about OffCoast role in responding to complaints that are raise concerns about a CPS finding that was made and whether there was a factual basis for that or not, and how our office responds to those complaints. And finally, I'll touch on the Certificate of Parental Improvement process, which is not technically a way to overturn the finding or challenge it, but it is a recognition of the impact that a finding of child abuse or neglect has on an individual and provides a way to ameliorate that adverse impact. So first I wanted to touch on some key decision points that lead into a CPS findings. And the first two are not related to the opportunity to challenge or appeal the decision, but rather go more towards how DCYF internally kind of screens everything from that initial intake to the CPS investigation process and the standards for an investigation and the basis for a finding that abuse or neglect did or did not occur. And then following the finding is, again, the Department of Children, Youth, and Families internal administrative review process. If a subject is not successful at that level, then they have the right to appeal to the Office of Administrative Hearings. Following a review by the OAH, the subject of a finding would have the ability to appeal the issue finally to the Department of Children, Youth, and Families Board of Appeals. And then after that, the next level of recourse would be an appeal to the Superior Court system. So I'll touch on these rather quickly in the interest of time. So I mentioned CPS intake, and in 2020, there were almost 95,000 calls to CPS reporting what the individual believed would be a child who was in need of CPS services or a child at risk of harm. CPS is charged with screening those intakes to determine whether the allegation that's alleged in the intake meets sufficiency or the legal definition of abuse or neglect. And of those 95,000 intakes that were received in 2020, 38% were deemed eligible for some type of CPS response. Now, that doesn't mean all of them received a CPS intake. Rather, 46% received a family assessment response, which does not result in a finding of abuse or neglect. An additional 16% were assigned to CPS risk only, which is a CPS assessment of the family, but again, does not result in a finding of abuse or neglect. So of those 95,000 intakes, roughly 14,000 screened in for a CPS investigation that potentially could result in a finding of child maltreatment. So when CPS investigation occurs, the parents have to be notified at the early point in the process that would not jeopardize either the child's safety or the investigation. There are certain standards or events that the investigation must include, including child interviews, interviews with the subject, collateral contacts, coordinating with law enforcement when appropriate, obtaining collateral information such as medical reports, etc. Once the investigation is completed, and the investigation has to be completed within 90 days, barring an exception or approval to exceed that 90-day period. After that's completed, the department determines whether or not, based on the information and evidence that's gathered in the course of the investigation, whether it's more likely than not that child abuse or neglect occurred. So the standard is more likely than not. And then again, the founded would go back to, well, what is the state legal definition of child abuse or neglect or maltreatment? When the finding is made, CPS sends in writing notice to the subject. It's sent by certified mail, return receipt requested, and CPS has to make a good faith effort to notify the subject of the finding and of their right to request administrative review and how they, what steps they have to take to exercise that right. The findings have significant impact, and I think that's why people were coming to the oversight board meeting and talking about the impact that it had on their life. So at least for 5 years, and usually longer if they do not obtain a certificate of parental improvement, but they're barred from paid employment or volunteer work with children or other vulnerable populations. That means they can't work in a daycare setting, they can't provide elderly care, they can't volunteer at a child's school, they can't become a licensed foster parent or be approved as a caregiver for a child. Again, in 2020, of the roughly 14,000 CPS investigations, 2,655 resulted in a finding of child abuse or neglect. So when a parent is notified or a subject is notified that they've been founded by CPS for child maltreatment, they receive the notice, they have an opportunity to seek review and challenge it, but it is time limited. They must make that initial request for an administrative review within 30 days. If they do not, then they lose their right to challenge that, after that 30-day period. Dr. Odimba will discuss this step in more detail, but the review is conducted by a DCYF management level staff that was not previously involved in the decision-making process. It involves a review of CPS records and reports, It also would consider any written material submitted by the subject about perhaps giving more information or a different interpretation of the CPS investigation, again, provided by the subject. That all can be considered by DCYF during the administrative review. DCYF must complete the review within 30 days and then again provide written notification to the subject, informing them of the decision, and if the finding was upheld, then of their right to seek review through the Office of Administrative Hearings. So here's a little bit more data. In 2020, of those 2,655 CPS investigations that were founded for abuse or neglect, the department received 751 requests for administrative review, and 112 were overturned at that administrative review stage. So we're on to the administrative hearings. And again, Judge Sheila Huber will go into this in more detail, but a quick overview. Again, 30 days, the individual has to request the review within that 30-day period. The Office of Administrative Hearings is independent and separate from the Department of Children, Youth, and Families. The Office of Administrative Hearing conducts a de novo review, which means that the administrative law judge is hearing this with a clean slate, if you will, and not simply relying on the underlying investigation and decision that was made by the department. The judge has a duty to create the record anew and make a decision based on that whether or not child abuse or neglect occurred. The administrative law judge issues a written order with the findings of fact and conclusions of law, and that written decision is then provided to both parties. So after the Office of Administrative Hearing, the next opportunity for review is to appeal the ALJ's decision to the DCYF Board of Appeals. And either the department or the subject of the finding can request review. It must be done within 21 days from the administrative law judge or the Office of Administrative Hearings order. And again, the Board of Appeals judge is also considering this with a blank slate. However, the Board of Appeals judge has to give due regard to the Office of Administrative Hearings administrative law judge's opportunity to observe the witnesses. A review judge may remand the case to the administrative hearings for further action. And again, the review judge will serve a final order on the subject as well as the agency and inform the subject of their right to appeal the decision to the Superior Court. In 2020, the Department Board of Appeals reviewed 14 cases, and of those, 12 affirmed the CPS finding, and in 2 cases, the CPS finding was reversed. To give a little bit broader perspective, looking over a 3-year period of 2019 through 2021 to date, the Board of Appeals reviewed 25 cases, and 22 cases they affirmed the CPS finding, and 3 were reversed. So I mentioned the Certificate of Parental Improvement. This is kind of a recent program that was initiated legislatively. It allows an individual that's subject of a CPS finding to request from the department a certificate of parental improvement that would allow them to be deemed to have the character and suitability and competence to have unsupervised access to children or vulnerable adults and work with those populations. important points is it does not overturn the underlying finding. A private entity, so a child placing agency or a private agency that might be hiring an individual or approving an individual to volunteer with children or a vulnerable population would still receive notification of the underlying finding of abuse or neglect, but they would also be informed that the individual has received a certificate for parental improvement. A person may apply for the CPI after 5 years have passed from the initial CPS finding. And as of March of this year, there had been 134 requests for a certificate of parental improvement. 29 were not eligible. And my understanding is most of those, they weren't eligible because that 5-year period had not passed. 68 certificates of parental improvement were issued and 4 were not issued. And they have been completing their reviews within a 24 calendar day period. So finally, before I turn it over to Joel, Dr. Joel Odimba to discuss the DCYF administrative review process, I wanted to touch briefly on OffCoast Rule. We do receive a lot of complaints from individuals that were founded for child maltreatment. Very often those complaints focus on or assert that there wasn't a factual basis, there was other information that should have been considered that wasn't. And OffCoast Rule is not to, we don't have the authority to overturn a finding, but rather we can look at the procedural requirements of the CPS investigation. We can look at, did the department conduct that CPS investigation in an appropriate manner? Did they interview the subject? Did they interview the children? Did they interview collaterals? And if we find a problem with that kind of procedural steps, then we can follow up with the department for corrective action. We're also looking at, did the department send notice? And sometimes we'll find situations where notice was sent to an old address or a wrong address. We've had situations where notice was sent, but it was not in the individual's primary language, and we'll bring that issue to the department's attention. Our response from the department in those situations when there's been a problem with notice is that they've been very kind of receptive to going back and correcting and making sure that the person actually receives appropriate notice, even if that means resending notice at a later date and reinitiating that review process. But again, our office does not have the authority to go back and say, well, we disagree and we think this should be unfounded, because as has been described and will be discussed, there's a particular process in place for an individual to challenge the finding in that way. So I will now, oops, let me go back. Joel, Dr. Odimba, I'll turn it over now to you for a description of what happens when your office receives a request for administrative review.
Thank you, Patrick. You did a great job in going through the process. If I have $100, I give it to you, but I don't have it. It's a privilege, board members, for me to interface with all of you. Some of you, in fact, almost all of you, I have worked with or interfaced with at one point in my almost 30 years career in DSHS, now DCYF. I love this job. My staff love this job. It's a difficult work, and these decisions are not easy to make, but we make it with diligence. And when our decisions are challenged, we listen, we go back, take a look at the work done, see if anything was missed. So like Patrick said, the standard of proof is what we look at. We follow the law, the procedures in investigation, making sure that everything is done correctly. I just have one slight update to what Patrick said in terms of the length of time it takes to complete an investigation. it is 60 days. It used to be 90 days, but since then we've updated our work to 60 days to complete the investigative assessment. And then within that time frame, we also make sure that the safety assessment and risk assessment are completed within 30 days. Again, like Patrick said before, we want to make sure that the standard of proof it complies with the law and policy, which is more likely than not the child has been abused or neglected. Internally, we call that a 51% rule. Once the finding is made, if it's founded or unfounded on both findings, we send out letters per policy. With founded findings, it has to be certified letter with return receipt. Sometimes, like Patrick said before, the parents have either moved or changed addresses, and we have to go back and try to serve the letter in person. If they refuse, we have to go back and document our efforts in our FamLink system, which is our computer system that documents child welfare case management work and activities. So like Patrick said before, once they contact us, it's usually our area administrator, the one responsible for managing an office, which comprise of zip code catchment areas. And that area administrator is independent, if you will, in terms of reviewing the work that was done to make sure that the investigation was appropriate and inclusive of all of the factors that should be looked at, subject interviews, collaterals, and making sure that we use medical information to substantiate our work. So in some cases, the area administrator, if they are not satisfied that we have met that standard, they would revise that decision. And like you saw in the data, almost always those findings are accurate because of the diligent work that goes into making those findings. And the ones that cannot be overturned, of course, the individuals have the right to appeal our decision. And if they have a complaint against an area administrator, I've had experience with a particular instance where a client had a complaint against an area administrator for bias. So we take that into consideration, and we have another area administrator review the work. Again, the goal here is to make sure that we are following the law and policies, and we are completing the work as needing to be done. And that's pretty much all that I have to add to that. It is a pretty clear process. Again, we can't satisfy clients all the time, but when complaints come in, we listen, we take that into consideration. Like I said before, we've always, we've in the past overturned some of these findings. Rarely do we overturn them because it's the work that's done with due diligence. Patrick, did I cover everything? I think you did a thorough job in explaining everything that needed to be explained. I think that's pretty much it for me.
Okay. Joe, could you?
I just want to add that in the findings letter that I have in my hand, you can't see it now, but it is pretty thorough, and the finding letters tells them what type of child abuse and neglect occurred, that they committed, and it tells them why they are receiving this letter. It goes into the basis of our decision, who, what, and where, and it also goes into the specific findings, how we arrive at the decision. And then we include in the letter what happens when you get a founded findings and some of the ramifications that Patrick went over are included in this letter. We discuss their rights. We tell them about the administrative law judge, which is the Office of Administrative Hearings. We tell them about that process. And also we tell them the timelines that they have. And then we provide them the law that we are governed by. And also at the end of that letter, it's a pretty thorough letter that they get from us. At the end of that letter, we provide them a review request that they have to review it within 30, they have to fill this out and return it within 30 days for the area administrator to review their concerns.
Joel, do you have any other comments about when it's assigned to an area administrator, kind of the process that he or she goes through as far as like reviewing case records in family and or getting additional information from the CPS worker and or supervisor, or how that kind of process and moves forward?
Yes, absolutely. Once they get the request for review of the findings, the area administrator begins by reviewing the work done in FamLink, electronic review of the work done, because everything is documented in FamLink. And for each review, they look at the policy, they look at the laws, they make sure that we have collateral information, that every that the finding is actually substantiated by records that we have that are uploaded into the system. And if needs be, they would perhaps talk to the worker and the supervisor to clarify some of the questions that they may have and before they make their final decision.
Okay, thank you, Dr. Odimba. All right, I think, and now we'll move forward into the next stage. So when the department does not overturn the finding and notifies the subject, then their next step would be to go to the Office of Administrative Hearings and have Judge Huber perhaps review what happened. So Judge Huber, take it away.
Okay, thank you. I just want to thank you for inviting me and for the opportunity to connect with so many friends who are child welfare friends who I haven't seen for a long time, and for the opportunity to explain what the Office of Administrative Hearings does as well. So I'll just jump right in, and I will assume that you don't know a lot about the Office of Administrative Hearings, and so if I give you too much information, I apologize for that. But OAH is a separate state agency. It was created by the legislature in 1981. And so it's a relatively new agency. Its purpose is to provide fair hearings to individuals and to entities who want to challenge agency decisions against them. And the purpose is actually in the statute is to improve the appearance of fairness in administrative hearings. So OAH actually hears a lot more than just the DCYF cases. It is not part of DCYF or any other agency. It hears cases involving more than 20 agencies and 150 programs, including the Employment Security Department, the Department of Social and Health Services, and there it is a lot child support, licensing of different facilities, adult protective services, developmental disabilities, those kinds of cases. The Liquor Cannabis Board, the Healthcare Authority cases, and the Office of the Superintendent of Public Instruction. There are a number of small agencies that are involved as well, and that includes DCYF. So in 2020, OAH received 75,146 cases for hearing. And of those, 1,071 were from DCYF. So the DCYF cases include the Child Abuse Prevention and Treatment Act cases, the CAPTA cases, and licensing cases, foster care, child care, the child care assistance hearings, challenges to disqualifications based on background checks, and also denials of the certificates of parental improvement. The Child Abuse Prevention and Treatment Act cases, which are the ones that I'm going to talk about today, are triggered by a federal law that requires states that accept captive funds to provide due process hearings to people who have a founded for child abuse or neglect. And of the approximate 2,000 founded findings of abuse or neglect that Patrick was talking about that go through Dr. Odimba's process, about 400 to 500 would then be appealed to the Office of Administrative Hearings. This is a separate process from OffCo. It's a separate process from dependency actions and a separate process from related criminal actions. So the process is quite relaxed and user-friendly. And I think that Dr. Odimba showed you the request for hearing. It doesn't have to even be on that form. An appellant can just write a note that says, I want to challenge the department's founded finding against me. And that would trigger the hearing. It doesn't have to be any kind of formal complaint. It can be faxed to our office, can be mailed, it can be hand delivered. There's just a lot of acceptance of how people work. OAH also has a website that is up on the screen now. And this website gives a lot of information to people about the many aspects of the hearing and how to use our portal. We have a portal that any party can access the records that are filed in their case, and they can upload documents that they want to use as exhibits or motions. They can upload those documents to our portal. And so the website shows how to access the portal. It has portal instructions, but if people are having trouble, the portal instructions tell them just to call the office and someone will help walk them through it. It also gives information about how to, or where they might be able to get low-cost legal assistance if they want that, what to do in the hearing. There is at one place a video about what a hearing looks like. It's not a child abuse hearing, but there is one that shows just kind of the more relaxed atmosphere of these hearings. So parties can elect to get notices either through the portal or by mail. And the hearings are informal. There's no black robes, there's no bailiff, they are usually by telephone, although they can be in person, and they also can, since the pandemic, be by video conference call. So all of the hearings are recorded, and the audio recording becomes part of the record. The parties in the cases that appear before OAH oftentimes represent themselves. They can be represented by an attorney or another person. They can be represented by a family member or a friend, a paralegal. They can be represented by anybody except an employee of DCYF. And appellants in our cases are represented by attorneys in less than half of the cases, which kind of gives a flavor of, or an approach to how we look at these cases, because in them there is a lot of explaining, and as I will kind of mention, we talk about the process, we give time for questions, and just let people kind of ask what they need, what they want. In the vast majority of cases, the department is represented by a Special Assistant Attorney General, Maureen Bartlett, and she does almost all of the cases. There are some of the CAPTA cases that are done by Assistant Attorney Generals, but most of the time the appellants represent themselves. So I want to talk a little bit about the process for these hearings, and that's on the next slide, I think, Patrick. The process actually begins with a request for hearing or the appeal, which is our intake. It's an appeal request for hearing, and it opens the case in our case management system, which is called PRISM. And then there would be a contact with the that once that it's done, there's contact with the parties to schedule what's called a pre-hearing conference. And the pre-hearing conference is usually lasts about 30 minutes. It's a scheduling and planning hearing. It is fairly informal. It's always by telephone. There is no argument and there's no testimony. The purpose of the hearing is to actually see if the parties can agree on a number of things. Those things are what exactly is the issue that's going to be decided in the hearing on the merits. And that issue is usually framed in a way that's fairly straightforward, which is, did the appellant physically abuse her minor child so-and-so, as described in the department's founded finding letter of whatever date. And it's usually that's about as much as they would say. We would also determine if an interpreter is going to be needed at the hearing. And interpreters were used in, they're used in approximately 20 cases per year. They would be, if there is an interpreter that's needed, they would also be, if it was for one of the parties, they would be also on the line in the pre-hearing conference. We'd look at whether there are any accommodations that are needed for any kind of issues that any of that the appellant might have. And we would talk about discovery issues. The department generally, as kind of a matter of routine, sends the entire investigative file to the appellant. And sometimes we give them a deadline for doing that if they haven't already sent it, or if they haven't made plans for it. But usually, at least when Ms. Bartlett is on the case, she will contact the appellant and ask how they want to have it, and she makes sure that they do get it. We also, at the pre-hearing conference, determine whether any party intends to call the child as a witness. If the child victim is going to be called as a witness, then we have to hold a special hearing, and we determine whether there actually is a compelling need for the child to testify. And if there is a compelling need, then we would look at protections that can be placed in the hearing itself, either have the child in a different location and only by telephone, or have someone with the child, have questions submitted in advance that would be asked of the child. But for the most part, the parents and the department do not ask for a child to testify in the hearing. So also at the pre-hearing conference, we do schedule times for any motion hearings that there might be. And we schedule a time for filing a witness list and an exhibit list, and also the proposed exhibits by the parties. We explain how to number those and how to mark them, how to take out confidential information and the kind of confidential information that needs to be taken out. We always have the department's documents, their witness list and exhibits due a month or or 2 weeks at least before the appellant's is due, so that the appellant has kind of an idea of what that would be looking like, and they will be able to kind of set it up. They can copy that. But we do attach a form, a blank form for the witness list and the exhibit list also to the pre-hearing conference order. And they can just actually write on that form as well. The final thing that we do is schedule a time and place for the hearing. And this is a conversation about how many witnesses that each side plans to have, and how many days it might take to complete the hearing. So we discuss whether the hearing should be by telephone, by video conference call, or in person. The vast majority of our cases are heard by telephone. It's also, the pre-hearing conference is also a time to actually address any questions that the appellant might have about the process, and about what happens at the hearing and what will happen next. And it's actually not only pro se appellants who are a little bit confused about the process, because I think that most attorneys don't practice in administrative hearings. So sometimes they are not as clear on what's going to happen next also. Once the pre-hearing conference is over, then there is an order that is written that memorializes the agreements. If the parties are unable to agree, then the ALJ, the administrative law judge, will actually make the decisions for them. And these will be detailed in the order. There also are pretty good details about how to set up your witness list, how to describe exhibits, how to redact, where to send those, not only to the Office of Administrative Hearings, but also to the other party, so that, that they know exactly how to do that, and also how to access the hearing. So before the hearing, there may be motions that are made, and sometimes these motions are for discovery motions. Sometimes they are motions to dismiss for lack of jurisdiction, and that the primary purpose of that, the primary reason why people don't have jurisdiction is they miss their 30-day time frame. So the statute is pretty tight that if you don't file within 30 days, then you don't have a right to a hearing, which keeps the ALJ from having any authority to actually hear the case. So, there might be those kinds of motions. Sometimes there are motions for summary judgment, and that's particularly true if there is a criminal conviction or some kind of related case where there are findings that are made by a superior court that might have an impact on what we've done. So after that first initial process, the order is written and it is sent out to the parties. That's the pre-hearing conference order, and it kind of guides the process as we go along. The administrative law judge then gets ready for the hearing, which is the next step in the process after the motions, if there are any, and usually prepares for the hearing by reading all of the exhibits and reviewing the applicable law of how neglect and abuse are defined. And then at the hearing itself, as Patrick said, it is de novo review. So it's a little bit different from other kinds of cases. And I think that one of the things that's different from both the way that Dr. Odimba and Patrick talked about it is that we don't look at the process of, is this investigation faulty? What we look at actually is all of the evidence fresh and make the decision based on that. We don't look at, was the department's decision reasonable? We look at, with all of this evidence from a new framework, is it more likely than not that abuse or neglect occurred? And so there is also, as Patrick mentioned, he's like stole all my thunder. So I already told you all of this. There is a statutory responsibility to ensure that the record of the hearing is complete. And so the ALJ is more involved in these cases than you would often see like in a trial court. Because if it seems like there are places in the record that are just not complete, we will ask questions of the witnesses, and that would include the parties, the investigator. We might ask questions that just haven't been brought up by the attorney or by the appellant. And if we think that there are records that we don't have, we will ask that they be submitted, and we will set a date for doing that. Sometimes those are records from maybe from a court hearing or from something from some other avenue that we think is just necessary for us to actually get a good grasp of the case. And so we will ask for those to be sent into to be part of the record. The other real difference is that in these cases, the Washington Administrative Code, the DCYF rules, are the first source of law. And the ALJ does not have any authority to invalidate those rules and must look at them first. It's the RCWs, the Revised Code of Washington, federal laws, and appellate court cases can be looked at only if the answer is not in the actual rule itself. So the department actually does have a lot of control over what the law is and how it's applied from our perspective, because we do look at those WACs first. There are instances, of course, where the WACs are not, and the statute even are not totally complete. And one of those is in is in the area of neglect, where there are cases that have said, what is neglect? It's not just simple neglect. And so there's some cases that we look at because they supplement what the WACs say. Usually hearings last at least 1 day. And some statistics that are in one of the slides show that I think in 2020, the average hours was 20.6 or something that's the average hours for a case in 2020. And so it's like 3 days is about what it is. OAH is open from 8 to 5. So our hearings can be from 8 to 5 or from 9 to 5. So the hearing begins with an explanation, and this is because most appellants are pro se. So the ALJ really works hard to ensure that they are able to fully participate and to tell their side of the case. So we explain what the hearing process is going to be, and the appellant has an opportunity right from the very start to talk about that process. So generally, the first thing that we do is we make sure that everyone has a copy of the exhibits that have been filed. Those exhibits, usually under our pre-hearing conference order, would have been filed by a certain date. And that would have been a month ahead of the hearing for the department and 2 weeks for the appellant, as just an example. So the exhibits are then described at the beginning of the hearing and offered into evidence at that time. And the ALJ does hear any objections and admits exhibits at that time, unless there's some reason to just reserve the consideration of it until later. The department's exhibits usually are the founded finding letter, which, as Dr. Odimba said, it's got a lot of the law in it, and it has an explanation of what the department did and what they found. The intake is there, the investigative assessment, the CPS investigators case notes, which sometimes are very comprehensive and lengthy. And then depending on the case, the evidence that the department offers might include police reports, medical records, medical consultation reports from department contracted medical providers, school records sometimes are there, counseling records, dependency petition and order, any criminal charging documents that are related to the case, and any other court documents that might be related as well, sometimes from a family court proceeding. And then the appellant's exhibits might include sworn statements from friends or from family members that talk about their character and that also talk about their reputation as a good parent. If they also sometimes will have evidence, documentary evidence from the school, particularly if there's a question about the child being difficult to manage at home, showing their behaviors. If there's a custody dispute between the parents, there oftentimes are guardian ad litem reports that might have been filed in a family law case or other things that were filed. So that's the first part of accepting the exhibits. And then the department has the burden of proving abuse or neglect occurred. And the standard is a preponderance of the evidence. That is that it is more likely than not that this occurred. And because the department has the burden, it goes first in the hearing. The hearing has really 3 parts: the opening statements, the presentation of evidence, and closing statements. So the opening statements are just statements about what the theory of the case is and what kind of evidence will be presented. There's no testimony, no real argument at that point. And the appellant can either do their opening statement right after the department makes theirs, or they can wait until the department has presented all of its evidence and then make an opening statement. After the opening statements comes the presentation of facts. And the department gives its side first because it has the burden of proof. So what it does is present all of its exhibits and its witnesses, and the appellant has the right to cross-examine those witnesses. And the ALJ, as I said before, often will ask the witnesses questions as well. The department's witnesses usually include the CPS investigator, sometimes the person who made the referral. This is particularly true if it was a mandated reporter, medical or school personnel or law enforcement. And then depending on the case, teachers, medical providers, child's counselors, law enforcement officers, the forensic interviewer, people who actually provided information to the department that they based their decision on. And the appellant's witnesses then usually include themselves, and they do usually testify themselves and explain their side of the case. Sometimes they have family members who testify and they have, or friends and talk about their reputation as good parents. Sometimes they have people who are daycare providers or others who might have an understanding of the child. Just depends on the issues in the case. All of the testimony taken in our cases is taken under oath. That includes the agency witnesses as well as any witnesses. And in doing the evidence, the rules of evidence are relaxed in these hearings. And so hearsay is admissible as long as it is considered reliable. And it would be reliable if it's the kind of information that people would generally rely on. And also there has to be an opportunity for the person who it is introduced against to cross-examine or contradict or challenge the evidence. So we have kind of a two-step process for hearsay evidence. And a lot of evidence in these cases can be hearsay because it is based on an investigation and also on statements that people make even to the appellants. So so some of it is hearsay. At the end of the department's case, then the appellant has the opportunity to present their witnesses, and there's cross-examination of their witnesses as well, including of the appellant, and questions also by the ALJ. So then after the presentation of the evidence, there are closing arguments. And these are statements of looking at all of the evidence and looking at the law, why should the ALJ rule in a particular way? And so each party has an opportunity to provide that information. And then at the end of the hearing, the ALJ explains what the next steps are, which are that there will be a written decision, which is called an initial order. And it is written within 60 days of the close of the hearing. And then it will be mailed to the parties, and either party, which we would explain, either the department or the appellant. And I'm not sure in the Board of Reviews who does this most, but either the department or the appellant can appeal to the DCYF Board of Appeals. The Board of Appeals decision is called a final order. And so if there is an appeal and there is a final order, that is the final order of the agency. And under the WACs, the department can't appeal that, but the appellant can appeal to Superior Court. The order that the ALJ writes as an initial order includes extensive findings of fact. And it also includes credibility findings if those are appropriate. And that's generally where there is conflict in the evidence. The ALJ makes a determination as to what evidence is more credible. There are conclusions of law, which basically takes the law that applies and applies it to the facts that have been found above the conclusions. Our orders are quite comprehensive and usually are between 15 to 25, 30 pages. So they look at everything that's been presented and then apply the law. The WAC requires the ALJ to affirm the finding, the founded finding, if abuse or neglect is supported by a preponderance of the evidence. The WAC also requires a reversal and a remand if it is not supported by a preponderance of the evidence. So the majority of appeals, and I actually just learned this in preparing for this, the majority of are actually more than 80% are dismissed before hearing. And the dismissals can be for a number of reasons. They can be because someone missed the time frame, and so it's dismissed because the ALJ lacks jurisdiction over the case. It can be because a party doesn't appear for the hearing. And sometimes that happens where the party just doesn't show up, and so then they are defaulted and the case is dismissed. It also can be because there is a motion for summary judgment, which basically would say that, that there's really no dispute as to these facts. And oftentimes it's because of some other collateral case, like maybe a criminal case where someone was convicted of driving while intoxicated with their children in the car. And so the department might make a motion to resolve it by summary judgment. And also the cases are sometimes just settled, and the founded is changed. And so the case is dismissed because it's changed. So in the majority of appeals then are dismissed, 80%. And in 2020, there were 9.38% of the cases were affirmed, and 5.54% were reversed. And I'm not great at math, but you can see that in fiscal year 2020, 458 cases were closed, CAPTA cases were closed. These are not necessarily the same cases that are filed in 2020. Some of these cases do take longer than a year to process. Most of them don't, but it might not be that you're going to get your case if you file in December or I guess in December or whatever of 2020, it might not be within that fiscal year that your case is going to get resolved. So it might be a different case here that is there. But my calculation, if 458 cases were filed and 83% were dismissed, that's 382 cases would have been dismissed before hearing. And then 43 cases would have been affirmed and 23 would have been reversed. That would have been 2020. So if it is reversed, then the case is also remanded to the department with instructions to change the founded to unfounded. The order explains how to appeal to the next level, and the DCYF Board of Appeals is the next level. And it also explains that if there is no appeal within 21 days, and that's the time frame, then the order becomes final. The initial order becomes final, and there's no right to appeal after that. So the date of it's from the date, 21 days starts from the date of mailing, and that date is actually on the order itself so that people can see that. And there's a form that is attached that says, that shows is a form for appealing to the Board of Appeals that has the case number on it and says, I want to appeal because, and so they can just file that, or they can file something else. In 2020, the average time frame for from the filing of a request for hearing, the appeal, to the date of the initial order was 220 days. And so these do take more time than the others. They are different from dependencies and different from the criminal actions and different from OffCo. So yeah, thank you.
Thank you, Judge Huber. I have a quick question. What is the impact of for example, a pending dependency fact finding on a appeal to the Office of Administrative Hearings that are when these are going on contemporaneously?
So we would stay any case where there is a pending legal action. So yeah, we have a process where it would just be stayed, and nothing happens. And that's also true if there's a criminal case that is similar. And in 2020, you know, there were a lot of cases that kind of got blocked in the court and because of COVID. So yeah, so it's been that was a little bit slow. A lot of cases have been stayed, and we have status conferences. Well, when we stay a case, we'll set a status conference for maybe 3 months out or 6 months out, and the parties we'll get together with the parties to see if anything has changed. And if it hasn't, then we'll continue the case and have it be stayed again so that it doesn't count within the time frame. But yeah, nothing happens because we don't want to have a conflict.
And in the dependency court system, if the court found that abuse or neglect had occurred, then that would be dispositive for
Yes.
the administrative hearing?
Yeah, there's actually one of the DCYF rules actually addresses that and says that if the court makes any findings, that you have to accept the findings of the court. Most of the time, the dependency orders that we see are C dependencies, the no parent capable. So they don't have a finding of abuse or neglect in them. But sometimes the facts that are agreed upon are submitted, are used by either party as, you know, these are what the facts are that the court actually accepted, and we will look at those. And we look at any, the findings of also in family law cases as well.
All right. Thank you, Judge Huber. Now I think we're at the question and answer phase of our presentation. And so I'll kind of open it up to the group if there are any questions.
Looks like Senator Warnick, you have a question?
Yes, thank you. And Judge Huber, I think you said that the appealing party could be represented by an attorney, but many are not. Is that correct? It just seems like quite a complicated process for someone who may not have legal representation. So I just would like to hear more about that.
Yeah, sure. It is. We try to make it so that it's not too complicated, but most of the people who appear are not represented by attorneys. They can be represented by someone else, and you don't have to have someone who's an attorney represent you. So it's not like court where you've got to be licensed to practice law in order to represent someone. You could have an advocate, a paralegal. You can have someone who is a friend or a family member represent you. But most people do represent themselves. And we as administrative law judges do try to assist. And so, for example, if someone is asking a question to the CPS investigator and they just are not able to get they don't seem to be able to get the kind of answer that they're looking for, or that the question is not aiming toward the type of response that they're looking for, we might suggest that they ask the question in a different way and say, why don't you ask the CPS investigator if she talked with this person and ask you know, if she did, what did that person say? Because sometimes they will ask leading questions, which we don't want them to ask, and that actually get kind of argumentative and don't really get to what we need to know. So we do take our responsibility of making sure that the record is clear and complete pretty seriously. And so we do assist them in a lot of different ways. And so if they seem confused at all, we would stop and we'd say, you know, what's confusing you, and what would help. So we do actually talk a lot about the process and what they can ask and what they can do, and they have an opportunity to really tell their side of the story, I think.
Well, that's good to hear. I just hear from people, constituents who feel a little bit intimidated, and so that's good to hear that that's what in your court anyway, that's what the process would be. But to have an assistant attorney general on the other side, it would just be a little intimidating, so.
And I think that that the department has, one person who is a special assistant attorney general who does almost all of these cases. She actually, she's actually very nice and very good with people. She doesn't object to much of anything that they do, and kind of. She does like talk to them, I know, before the hearings, and so a lot of times issues resolved before they even get there because they've talked. So I don't think it's not as adversarial as you might see in courts. We try to make it easier, and when we meet in person, we are at a table and not in a courtroom setting. So people are sitting at the same table, and but it's still, you're right, it's intimidating, it's hard, and it's someone who has had, someone say that they have abused or neglected their child.
Right. Thank you.
Other oversight board members have questions for any of the three panelists? Okay. Well, I do want to respect everyone's time. If that is the case, I want to ask both or all three panelists, particularly, if you are open to receiving any questions after this meeting. If board members do have questions as follow-up, if you're open to us emailing those or furthering the conversation after this meeting.
Yes, I'm open.
Thank you, Joel.
Good. And as
Yes.
you see, I've provided our contact information as on the last slide. Thank you.
Thank you all very much. Again, just one opportunity if any board members have any questions specifically from the presenters here about what was presented.
This is Ruth Kagi. I would be interested, these cases have obviously gone through many levels of consideration. So I am trying to sort out what the role of the oversight board is in cases where people feel that they have not been fairly treated. And so I'd really be interested in any perspective you have on that, or any suggestions you have.
Is that question for me, Ruth? Question for others?
It's a question for the panelists, but Patrick in particular. I mean, when cases are brought to us, I think the issue was raised at the last meeting. The appropriate place to look at this is the Ombuds office. So Patrick, do you have any thoughts about the role of the Ombuds as opposed to the role of the Oversight Board?
Yes, thank you. It's all, timing is so crucial in these situations because their opportunity to seek redress of a finding is time limited. So like when our office gets a complaint kind of within that window, then we're able to kind of respond. Well, let me kind of back up about that. Even if the 30 days has passed, we're able to take action if the department has missed a step. So for example, if the letter wasn't sent, or it was sent, but it was sent to an old address, or there have been situations where there's been an issue of who signed for the letter and was it actually the subject or not, et cetera. We can work with the department to address those issues. We can also work if there is, with an individual, if there is a again, a procedural problem with the way the CPS investigation was conducted. And an example of that that comes to mind is CPS made a finding that child abuse had occurred, and during the course of their investigation, they had not interviewed the subject. And that's a problem. And the department agreed and reopened the investigation and basically kind of started from scratch. And that eventually led to a favorable outcome for the subject of that investigation. So there is an opportunity for our office to respond, but what we are not able to do is, if the department has followed law, policy, and procedures, and they come down and based on the facts that are gathered during the course of the investigation, they conclude it's more likely than not that abuse or neglect occurred. We don't have the ability to say, well, we disagree with the department's decision. And they would need to exercise their opportunity to seek administrative review or appeal to the Office of Administrative Hearings.
Okay, thank you.
And again, my sense of after the last oversight board meeting, I thought it would be helpful for the board members at least to have a full understanding of what opportunities to challenge a finding exists for an individual.
I think it is. Thank you.
If I might add, I think that the certificate of parental improvement was not here before. I think through the advocacy of the community and also the legislature that listened to these complaints and gave the opportunity to those individuals to redress some of these issues after a period of time, I think that's also helping to address some of these concerns that are coming up.
Do you happen to know how many people have actually accessed that and gotten certificates?
Patrick, I think you're still on mute. Yeah, no, Patrick.
Okay, this is in regard to the certificate of parental improvement.
Right.
Yeah. So let me go back to.
I'm sorry if I missed that.
No, that's all right. So this is about 2 months old, but from the middle of March, there were 134 requests and 68 were issued.
Okay.
And of the 29 that were not eligible, my understanding from the department is most of those were individuals that had submitted the request, but they did not meet the 5-year requirement from the date of the finding to the request for the CPI.
Okay. Thank you.
Great question, Ruth. Is there any other questions from board members, from any of our individual presenters in the areas that they presented on? Okay. Well, I want to once again thank all 3 presenters, Judge Huber, Dr. Odimba, and also Patrick, for coming to provide this information to the board. I think it's incredibly valuable. We have recorded this meeting, so we will provide it to other board members that were not able to attend today, obviously for schedule conflicts, but make sure they get that information along with your slides, Patrick. So thank you all, and we will definitely make sure we keep the conversations going, and we'll follow up with any follow-up questions that do arise from our board members as a result of this.
All right, thank you, everyone.
Thank you.
Thank you,
Bye-bye.
everybody.